In this presentation, we're going to go over what is an affidavit. Many people have maybe heard the term, don't know what it is, don't know what it's used for. This brief introduction will go over basics of writing an affidavit and what's actually in an affidavit. So what is an affidavit? An affidavit is a written sworn statement which contains facts, as well as proof of these facts by way of exhibits, and is generally used in a court proceeding or other legal matter. An affidavit must be based on facts you believe to be true and based on first-hand knowledge. The points in an affidavit are generally done in a logical order, each point being numbered sequentially or lettered sequentially, and you generally limit each paragraph to a particular point. Do not write an entire paragraph and number it as one point. All affidavits must be sworn in the presence of someone who is legally authorized to do so. Now, if you're in your own area, you may just be able to get some lawyer to swear the affidavit for you. Or if you're working internationally, you may have to go through a commissioner of oaths. The particular rules governing your affidavit will depend on your location and or your court. This is just a general overview, which in this case I've made apply to Ontario. However, the same principles apply to England or Alberta or anywhere else in the world. There's many types of affidavits. There's an affidavit of a name change. There may be affidavit of a death. Those should be self-explanatory. Affidavit of identifying theft. So if you're trying to lay a criminal charge, you may have to swear an affidavit, and you may or may not be able to swear the affidavit and then file your own claim. In some locations in Canada, for example, the police department can do criminal claims, whereas the rest of the population can only file a civil claim if we're dealing with strictly with criminal or civil claims. There are also, like family court, may have a different affidavit. You may have an affidavit of events which states the events which transpired which relates to your specific claim or your specific defense. You may have an affidavit of inheritance which identifies heirs of property which deceased or died without a will. This affidavit is also known as an affidavit of heirship in some states. As stated earlier, there are many types of affidavits. There's an affidavit of residency or residence, which verifies your address and anyone living with you, may be applicable to certain applications. There's a divorce affidavit, including statements from both parties looking to dissolve a marriage or a civil partnership. There could be a child custody affidavit, which provides factual details as part of a child custody case. There could be an affidavit of domicile, securing property or transfer or delivery to legally entitled persons in case of a decedent's death. There's also a general affidavit, which is a sworn or written statement that verifies facts when responding to a court motion or a court action. This is the type of affidavit we are going to address here today. There's also a financial affidavit, which shows an income and expense or a debt and asset for a court, is generally used to determine child support or spousal support, and is usually filed also in a divorce case. Okay. Then there's the affidavit of service. This shows or states that you have served your opponent with a particular document or documents on a given day. Generally, a court will not accept paperwork into the court unless you've already served the other side with the same documents. So generally what you do is you draft up whatever document you're going to deal with, and that could be a statement of claim, could be a statement of defense, could be a motion, or it could be an affidavit. Once you have drafted that document, and if needed, got it sworn, you generally have two copies. You leave one with your opponent, and you take the other one down to the court with a properly executed affidavit of service to state that you have served the other side with this particular document or documents, and then the court will accept those documents along with the affidavit of service. If you do not fill out the affidavit of service and attempt to file documents in a court, the court will generally disregard this and not allow you to file your documents, and then you have to go back and clean up the mess that you've created. I will be doing a separate presentation dealing specifically with court procedures, and it is hoped that by providing these short introductory seminars or webinars, that the person can follow through a particular order or particular playlist, and that those steps can be followed, and we can simply summarize those in a how to do court procedures presentation, which will be done at a later date. Some people may be asking, why do I need an affidavit? An affidavit is provided to your opposition along with your statement of defense or your statement of claim or your motion in order to allow them to respond to each point that you make on a point-by-point basis. This minimizes you having to make an oral argument on the floor of the court, as well as protecting you in the event that the judge does not permit you to give all or any of your oral arguments. The affidavit, along with the exhibits, is then filed into the court after you have served your opponent, and you, as I stated earlier, must include an affidavit of service when you do so. A court is bound to regard all facts that are stated, both written and orally. And many times a self-litigant comes into a court or into a hearing, and the judge will not allow that person to present all of their oral arguments. If you do not have an affidavit or other similar document filed, then you cannot get a fair trial. So by filing this affidavit, you are protecting your rights, because if the judge does dismiss you or tell you you can't, proceed any further, I've heard enough or whatever, you have a legal recourse now to file an appeal to a higher court, and you can then file the same affidavit in this appellate court, sometimes known as a divisional court or an administrative court, depending on where you're from, and the judge will say, okay, now the only time you can file an appeal is if there was an error in law. Well, if the judge did not review all of the facts or did not take them into consideration, you have perfect grounds for your appeal. If you did not file your affidavit and there is very little evidence on the actual transcript from the court, then you may have a problem. This is why it's best to go through and file the affidavit. You can also use this affidavit as kind of a cheat sheet, if you will, to go on a point-by-point basis and address issues. You also have to give your opposing party a chance to see any and all evidence that you intend to use in the court, which includes pictures and other documents which may be necessary, and you use this affidavit process to file those documents in front of your opponent so that he or she may address those facts, and you may be able to minimize 20 points in a court case, for example, down to 4. This is why it is a very good idea to use the affidavit process. What goes into an affidavit? Well, below there's 6 key sections that must be included in any affidavit. The title, this can include a court case number and other details along with your name. For an example, affidavit of Jane Doe. It also contains a statement of identity. This is where you tell the court about yourself. For example, can include your location, your occupation, your date of birth. Then there's the statement of truth. This section requires you to swear that the information that you're about to present is true to the best of your knowledge. You cannot put in things in here which are hearsay evidence. Hearsay evidence is not permitted, and we will discuss this further later on in this presentation. Then you have your statement of facts. Okay, this is where you point by point lay out your legal arguments or your legal proof as to your claim. Okay, and you generally do this in sequentially numbered or lettered points. So if you have to make 6 points, do not write one paragraph and call it, point number 1. What you would do is you would break it down to point number 1, point number 2, point number 3, point number 4, point number 5, point number 6 to get your 6 points across. I will show you an example of this further on in this presentation. Then you generally file a closing statement of truth. This is where, again, you swear that the above-mentioned information is correct to the best of your knowledge, and then you take that document and you bring it to somebody who is authorized to either notarize or affirm the document. If you're working locally within your own province or your own state, you can generally get somebody who's authorized to do that, and that could be a notary or it could be a lawyer. Many times a lawyer will do it and they will charge you a nominal fee. They're not supposed to charge you the fee, however they do, and nobody generally says anything provided it's reasonable. If you are going internationally, you may have to get a commissioner of oaths to swear or affirm the document in order for it to be accepted within your court. The first thing, as I said, was the title of your document. If you look at this document, this is an affidavit which would be accepted in an Ontario Superior Court. You'll notice at the top of the document it says court file number CV20, which generally gives you the year, and then there's a series of numbers, and those numbers are assigned by the court. Every document you file into the court will have a similar heading. Then it says Superior Court of Justice, which identifies the level of court. And then it says between Joe Smith, which is the plaintiff. The plaintiff is the one who's bringing the action forward. Some people call it a complainant, depending on where you're from. And then the second part of it is the defendant or the respondent. In this case, it says the Corporation of the City of North Bay and Fred Short. This is a fictitious entity. I'm just providing it as an example. Fred Short would be the CEO or the mayor or the chief building official, depending on your specific case. In this example, Fred Short would be identified as the CEO or mayor of the corporation. And then it says the affidavit of Joe Smith. When you get your court form, you generally have a place that says general heading, and you have to modify the court form to reflect the proper information, and this is the type of information that would go in the general heading. You can generally find a court form if you look up, in this case, for example, Ontario Court Forms, General Affidavit. Then you have the Statement of Identity. And in this case, the Statement of Identity is combined with another portion, so I've highlighted the appropriate part. Here you're saying, I, Joe Smith, of North Bay, Ontario, in the district of Nipissing, and I've deliberately spelt it wrong, am the homeowner and plaintiff in the above action before the court. So you're identifying who you are in relation to this claim, or in relation to this case. You are telling them point blank, you're the homeowner and the plaintiff. So there's no disputing who you are related to this here claim. Then you have the statement of truth, and it basically goes along to say, make an oath and say or affirm. And what you're telling the court is, you're using this to swear that you're going to present all the facts that are accurate to the best of your knowledge. A statement of truth is equivalent to swearing under an oath in a courtroom. Now, at the next point, we have to actually introduce our facts or our statements. The next portion of the affidavit is the statement of facts. So once you have the above information that we've just gone over, done and complete, it is my suggestion that you download that file or copy that file to a safe location. This way you can use the same information that's already laid out when creating additional documents, such as an affidavit of service, or if you have to file a motion, or an appeal or anything like that, you have the proper layout already completed for you. Saves you trying to recreate what you've already done. So now we get to the statement of facts, and this section of the affidavit is likely to be the longest, and the statement of facts is generally laid out in short paragraphs outlining points that you wish to address. Each paragraph should be a separate point where possible, and they're generally sequentially numbered either 1, 2, 3 or A, B, C. Do not try to intermix them, and try to keep them in a logical order so the judge doesn't have an issue. And I also recommend that you list your exhibits in a logical order as well. So if you have Exhibit 1, it should be the first exhibit that you reference within your paperwork. Don't start with Exhibit 4 and then Exhibit 18 and Exhibit 2, and there's your 3 points. Do it in logical order. Stick to the facts, and do not interject your observations or your opinions in this portion of the affidavit. Your personal opinions on a particular matter are not part of an affidavit. They are simply facts which you can verify or reference. Here is an example of a statement of facts. This is just an example. It does not reflect an actual court case, although it very well could. So point number 1, the corporation of the city of North Bay has over a number of years charged property taxes to people within Nipissing District, contrary to Section 17, Sub 1 of the Municipal Act attached herein as Exhibit 1. You'll notice that I have the Exhibit 1 in dark print, bold print. Now, the second point says, given the facts that fraud does not have an expiration date regarding a time to make a claim, the court would legally be bound to order the corporation of the city of North Bay to return funds I have provided to them over the last 30 years in the amount of $64,800. As the fraudulent means were used to trick me into thinking I had an obligation to pay property taxes based on the municipal tax bill attached herein as Exhibit 2. You can see here what I've done is I've put in Exhibit 1 as my first point. I've put in Exhibit 2 as my second point. You can put in as many points and as many exhibits as you like, although courts generally try to limit their submissions to somewhere in the neighborhood of about 30 pages or so. Now, in some cases, I have filed affidavits that have several hundred pages because I may be quoting several sections of several laws. In this case, I also may have exhibits too, which have 4 or 5 or 6 or 10 or 15 pictures to prove my point, in which case I cannot limit it to 30 pages. Certain courts will require you to get special permission if you intend to file an extremely large affidavit or extremely large document of any type. Now, this was provided as an example. However, the section of the law that I quoted, Section 17.1 of the Municipal Act, is actually Section 17.1 of the Municipal Act. We'll get into that in a minute. Then there's generally a closing statement. Once you have done all of your facts in a point-by-point basis, as shown earlier, you need to close everything out with another statement of truth. All you need here is a quick summary that everything you've outlined above is true and to the best of your knowledge. So in this example, I, Joe Smith, once again swear that the information in my sworn statement above is complete representation of the facts to the best of my knowledge. It's a fairly simple statement. Next thing you're going to have to do is take your document and you have to get it sworn. Now in this case, I left the document as it would appear when you download the general affidavit because I want to go over something here to make sure it's clear. it says sworn or affirmed before me at the city, and you would change the city, town, etc. to the name of your town. Okay, and you can change city to city if it's a city, or town to a town, and then it says of, and it has a line. You simply modify that line to indicate the name of your particular city or town, and it says in the country, region, or municipality of, and you would put, in this case, municipality of or district of Nipissing, on date, and then you fill in the date. The commissioner for taking affidavits will fill in the rest of that particular side of the document, the box, if we will. You are the deponent. Deponent is somebody who's actually swearing the affidavit. You must bring identification with you when you go to the notary or the lawyer or the commissioner of oaths and swear the document. And once you're in front of them and you give them those pieces of identity, they will then ask you to sign where it says signature of deponent. Some cases it may say signature of affiant. It's the same thing. Slightly different form, same concept. Now, when you have an exhibit, as I stated earlier, you must include your exhibits with your affidavit. They go after the text. So the first exhibit will be after the sworn page. Now, some people have a specific page that says exhibit or tab 1, exhibit 1, or exhibit A. Other people simply put the exhibit word on top of the document or on the document somewhere. The person who swears your affidavit or notarizes it will generally put a specific stamp somewhere on the document and fill in little boxes with on this stamp, and then have you sign it. So you only, as long as it's somewhere on the document. Each exhibit has to be signed and sworn. And you can have your exhibits as Exhibit 1, 2, 3 or Exhibits ABC. The notary will review and sign these as well. Be sure you tell them that you are having exhibits attached to your affidavit. And as I said earlier, they're at the back after the portion that you swore earlier. Now, in this case, I've highlighted the appropriate section of the particular act that we're dealing with. Now, we see here it says restrictions in financial matters. Sections 9, 10, and 11 do not authorize the municipality to A. Impose taxes, B. Borrow or invest money or sell debt, C. Incur debt without borrowing money for the purpose of obtaining long-term financing of any capital undertaking, D. Enter into an agreement for the purpose of minimizing cost or financial risks associated with the incurring of debt, E. Make and grant a loan, F. Take any other prescribed financial action, G. Become bankrupt under the Bankruptcy Insolvency Act Canada, or H. As an insolvent person, make an assignment for general benefit of creditor under Section 49 of the Bankruptcy and Insolvency Act Canada, make and propose under Section 50 of that act, and then it gives the appropriate reference. Now, in our case, we see Sections 9, 10, and 11, and I didn't get into 9, 10, and 11 under this act, but I will tell you now that Section 9 is related to a natural person, which basically confirms that the municipality has no more rights and duties as any other natural person. Now, there's two classes of persons. There's natural and there's artificial. A natural person is a human being, the same as you or I. An artificial person is a fiction corporation entity and is generally designated by all caps letters. Section 10 and 11 deal with economic development and regulating certain businesses for consumer protection. Now, we can see from this document they're not permitted to impose taxes, and that was the argument for our case. It also says that they can't incur debt without borrowing money for the purpose of obtaining long-term financial of any capital undertaking, which may be fine. It says enter into an agreement for the purpose of minimizing costs or financial risks associated with the incurring of debt. So therefore, if the municipality hires a lawyer or a legal representative, they're entering into an agreement for the purpose of minimizing cost or financial risk because they intend to put that risk back onto you, the homeowner. So that right there is illegal. But the most important thing is, in our case here, we're trying to fight the property tax issue. So therefore, Section 17(1) bracket A would imply to imposing taxes, which was the basis of your claim. You notice here I did not include the entire Municipal Act and print the entire Municipal Act out. This is because the judge doesn't want to read through 100 and some odd pages, and if you're going after the municipality for more than one thing, you may in fact have a 5-inch binder with 300 and some or 400 and some pages in it. The judge doesn't want to see all that. So I've just highlighted the important portion of it. You can, if you wish, and it is a good idea, to generally photocopy the front page of whatever act that you got your information from, or whatever book you got your information from, and then on the second page, provide the highlighted section. We will get into more of this later when we deal with future presentations. However, this should give you an overview on how to write an affidavit. When you go get these forms, you can look them up online, and as I said earlier, you may have to modify the form slightly. Now, in the case of UK government, they actually have a form already filled, basically more or less filled in, and you fill in certain sections of it. You can even do it online. However, in Ontario and in other places in Canada, you have to download the form in hopefully a Word format and then make the appropriate modifications as needed. The information provided here is in fact real as far as the statute or the act goes. However, the names on the initial documents have been just a fictitious creation to demonstrate the proper procedure in writing an affidavit. I hope you found this information useful. It has been brought to you by Denied Truth, and we can be reached at deniedtruth@yahoo.com. The link on the right-hand side of the page is the link to our Telegram group, of which we now have several. And then we are also going to be putting up a website, which hasn't been done yet, denied-truth.com, where files and other information will be there for your pleasure and your download if you wish. I thank you for taking the time to listen to this presentation. I hope you found it informative, and I look forward to bringing you additional content as time permits. Thank you for your time.